Right, welcome to week 6 in Legal Issues and Corrections. This week we're going to look at the Fourth Amendment in Chapter 10. It's only one chapter, but there's a lot of content here. So when we talk about searches in prisons, we're basically talking about two types. We talk about searches of the cells or inmate living quarters and of the person or prisoner themselves, and that can include some of these things as an example. Other types of searches would be physical areas within the facility, such as prison grounds, visitors, employees. The reason for searches including looking for ways to escape, assaultive behavior on parts of inmates, and ways to introduce contraband. Look for escape implements, weapons, contraband like drugs and money. Hudson v. Palmer, 1984, the true correctional officers in Virginia prison did a shakedown search of inmate's cell and locker looking for contraband. Found a ripped pillowcase and a trash can in the cell. Charges filed against the inmate for destroying state property. The inmate was found guilty. The inmate filed a 1983 action. And also alleged that he was being harassed. Was treated as a due process claim. The court held that because the state had a remedy for seeking compensation, there was no due process violation, even if the actions were done intentionally. On the main issue, the right to privacy in prison cells, the court held the Fourth Amendment provision against unreasonable searches does not apply to a prison cell. Cell searches may be done to the extent that's necessary for maintaining security and order, and any items that are found to be contraband can be seized. Basically, Hudson v. Palmer stands for the inmate having no protection of the right to privacy in prison. Traditionally, we have a constitutional right against unreasonable search and seizure, but in prison, the traditional Fourth Amendment terms are fundamentally incompatible with the close and continual surveillance of inmates and their cells required to ensure institution security and internal order. And that's a quote right out of the case. Bell v. Wolfish, we talked about that case before. It occurred at a federal detention center, dealt with various constitutional claims, including two search issues. Searches of inmate living quarters and visual strip searches. Most inmates at that detention center were unconvicted and confined while waiting trial. The prison staff conducted random, unannounced searches of inmate living quarters. Inmates usually would be removed from the living area during the search. The inmates complained that the cell left in needless disarray. Items were destroyed or damaged, asked to be present during the search. Prison officials opposed, said it would lead to friction between inmates and staff, allow inmates to attempt to frustrate the search. The Supreme Court held an inmate had no right to be present during a cell search. Room searches represent an appropriate security measure, and it's just necessary for the job. The Lanza v. New York, 62. Visiting room conversations of jail inmates and brother was electronically captured. Based on the contents, the inmate was called before the state legislative committee investigating possible corruption, and the inmate refused to testify and was convicted for that refusal. He claimed it was improper for them to record his conversation, claimed his punishment for refusing to talk about the contents of the intercepted conversation violated his constitutional rights. The court disagreed and upheld the conviction. It says that jail shares none of the attributes of privacy of a home, automobile, office, or hotel room, but the court did note that relationships with special legal protections, such as attorney-client, would at least have as much protection in jail as the outside world. In U.S. v. Hearst, 77, inmate and her friend spoke over a phone during a non-contact visit. Conversation was monitored and recorded. It was later used against the inmate at a trial. She was convicted on appeal. The issue was whether making and using that tape was a violation of the Fourth Amendment. The appeals court upheld the process and said the jail had a justifiable security purpose for monitoring and recording the conversation, and also held that once legitimately in government control, the tapes could be turned over to the FBI and used as evidence. There was a lot of these cases regarding monitoring phone conversations, and basically the courts pointed out that prisoners were aware that there's a potential of their conversation being monitored. Another area of searches is strip searches. In 77, male officers in New York women's prison were assigned duties in sleeping quarters. Females filed a 1983 action, said they were allowed to be viewed in various stages of dress. Union representing the corrections officers opposed the lawsuit. Officer arguments primarily based on their equal employment opportunity rights. Appeals court endorsed a plan in Forts v. Ward, allowing inmates to cover windows when changing clothes or using a toilet. The court also directed parties to explore the type of sleepwear that could be provided to achieve the protected desired by the inmates. These actions achieve some accommodation of the competing rights of the parties. And then the Supreme Court decision in Bell v. Wolfish, we mentioned earlier, dealt with body cavity searches during strip searches. In federal prisons, inmates required to undergo a same-sex strip search after every contact visit with a person from outside the prison. Part of the search required a visual inspection of body cavities. Prison officials said they were necessary to find and deter the introduction of contraband. In Wolfish, the Supreme Court upheld that practice. It said a detention facility is a unique place fraught with serious security dangers. They allowed such searches at the conclusion of visits without a necessary finding of probable cause or reasonable suspicion. In general, the courts have shown reluctance to allow or approve strip searches of persons immediately after their arrest or being taken into jail. There needs to be some kind of reasonable suspicion there. Across the court, or the board, courts have disapproved strip searches of persons arrested for minor offenses. And a felony alone isn't necessarily grounds for justification of a search. Searches need to be done professionally. There's usually some training, instructional videos on this type of stuff, conducted in a private place, out of the view of other inmates, out of the view of outsiders, without verbal misconduct. Pat searches or frisks are commonly done as inmates move about the prison. Such search is also done as the inmate moves out of or into prison. Searches involve running the hands all over part of the inmate's body at the top of the clothes, contents of pockets, or anything that's carried or examined. Cross-gender pats are generally allowed. Individual courts may place some restriction. Most extreme case was Jordan v. Gardner, where the court held that cross-gender pat searches of women could not occur in prison. That was decided on the basis of an Eighth Amendment claim, not a Fourth Amendment claim. It's finding that many women have been physically and sexually abused prior to prison. A pat-down search by a male officer would traumatize them. Simple instrument or x-ray searches occurs when the staff has reasonable belief the inmate is concealing contraband, when a visual search isn't possible, or there's not sufficient evidence. Pat searches, other searches, medically trained staff would do the search. X-ray searches handled by medical staff. There's blood and urine tests, breathalyzers. In this area, it's really important to consult with legal locally to make sure that it's something that's allowed. The book also talks about visitor searches. Most prisons have warning posters advising visitors not to bring in contraband into the facility, and they may be subject to search of their person or property. Visitors usually have a greater degree of privacy expectation than inmates. However, once they enter prison, security concerns are pervasive and they can be checked. Could be asked to walk through metal detector, pat searches by same-sex subjects, search of their bags, briefcases. If visitors refuse to cooperate, they can leave. Things like strip searches would require reasonable suspicion. In that case, if time allows, it's best to contact local law enforcement or get a search warrant for strip search of a visitor, or even a pat search of visitor's possession, including a car. Searching employees. These are sensitive, ordinarily done only under finding reasonable suspicion. It could be a situation where employees are participating in misconduct of some kind. Search determination could be found based on confidential information even provided by inmates. Staff should be advised that they could be subject to search. To collect evidence and be certain that allegations or suspicions are well founded, it might be necessary to do searches of employees, lockers, cars, clothes, other areas. And law enforcement officials and counsel should be consulted in these situations, and local court rulings on searches should be carefully followed. The rule of thumb is you need a reasonable suspension, and search warrants usually the safest way to go.